Hello, everyone. Thank you for joining us today. My name is Jana Unislawski, and I am the Memory Disorder Clinic Coordinator at the University of Florida. I'm also one of the co-chairs for the Mid-Florida Dementia Care and Cure Initiative Task Force. Before I introduce our next speaker, I would like you to type in any questions you have into the chat box. The Expo staff will come in and answer any questions, and then we'll also have a brief Q&A with Lynn at the end of this session. So thank you all for attending and being here today for our first annual virtual Dementia Resource Expo. So I'm excited to introduce Lynn, who is a certified elder law attorney, and I will go ahead and turn it over to Lynn.
Thank you, Jana. Good morning, everybody, and thank you for attending this. I chose today to speak or offer a presentation about guardianship. But also, I want to share with you alternatives to guardianships, because I don't believe that a diagnosis of dementia necessarily means that your loved one needs to be placed into a guardianship. So my plan today is to discuss guardianship first, because I think that that is something that many people have questions about, and it may indeed be the appropriate response for your circumstance. But I also want to spend a fair bit of my presentation discussing how it is that guardianship can be avoided. And that is quite an honorable goal to have. So first of all, what is guardianship? And who is it for? Why is it necessary? And what is the process? Guardianship is a legal process, and it is the process by which a judge, a circuit court judge in Florida, determines, based upon clear and convincing evidence, that the person who is alleged to be incapacitated indeed lacks the functional ability to care for their person and or their property. So what does that mean? It is not the doctor, not to dismiss doctors by any means. It's not sufficient for a doctor to say Lynn has the early stages of Alzheimer's or frontal temporal dementia, and therefore she shouldn't be left alone, or she shouldn't be writing checks. That does not constitute a guardianship. It is at the culmination of a rather lengthy process that the circuit judge will determine that Lynn lacks the functional ability to take care of herself. I lack the ability to understand that I need to eat on a regular basis. I lack the ability to understand that bathing and certain and personal care is essential to my personal well-being. I lack the ability to understand that if I write a check for $1 million, that far exceeds my Social Security benefits payment. So I lack the ability to understand that just because someone calls and says they're my grandson, by the way, I don't have a grandson, that I should write this person a check. So that is the functional sort of capacity we're looking at. So only when the judge determines that is the alleged incapacitated deemed to be incapacitated. So so then what happens as a result of guardianship? What happens is that my rights to do certain things are removed from me. So there's some of the rights that can be removed are things like my right to determine where I want to live, my right to determine who I can visit with, my right to contract, my right to decide whether or not I'm to travel. These are some of the things that can be removed from me. And you can see, therefore, because guardianship actually involves the removal of personal rights and property rights, that from the state standpoint, this is absolutely the last resort. We absolutely want to try and find something less restrictive. And it's those less restrictive alternatives I'm going to get into in a minute. But let's talk a little bit more about the guardianship process. So if you feel that the guardianship process is the correct way to address the issues, there are actually going to be two matters that are going to be filed with the court. The first one is a mental health matter, because that's where the determination of incapacity is made. And then immediately after that, we're filing a petition to have someone appointed guardian. Why do we have to do that? If you succeed in having your loved one's rights removed, or the person who's alleged to be incapacitated, we're removing their rights, we need to have somebody to whom to immediately delegate those rights. We can't have a judge say, Lynn lacks capacity, oh well, next. We need to delegate the rights that we're removing from Lynn to someone who can be trusted to take care of Lynn and to fulfill those, or to assume those delegated rights. So what's the process? So we file a petition to have Lynn determined incapacitated. Someone who knows me well enough, doesn't have to be a doctor, could be a family member, could be a concerned friend, can say, Judge, I believe based upon what I'm seeing of how Lynn's behaving, or what it is that I know of her diagnosis, that she lacks the capacity to perform some or all of her rights. So that's the first part. Then the next thing is we file a petition to appoint someone to serve as my guardian. Now, this person can be a friend, it could be a family member, it can be a child, it can be a professional guardian. This person must have a clean criminal record. They have to be able to pass a Florida Department of Law Enforcement Level 2 background check. They have to submit to a credit check. There can be absolutely no felonies anywhere in any part of their past. People tend to get a little forgetful about minor infractions that they thought perhaps won't count. They do. And that your application or your petition to be appointed guardian would be immediately dismissed on those grounds. Once we've submitted those to the court, and you do need to have a lawyer to do this for you, once we've done that, the court will appoint examining committee members. These are 3 people that have been specifically trained in the area of legal capacity, what it takes to satisfy the legal requirements to be found competent or capacitated or incapacitated. By law, one of those people has to be a doctor, and it cannot be the doctor of the person who's alleged to be incapacitated. It has to be someone who's appointed by the court. In addition, there are 2 other people that participate in the exam committee. Very frequently, this is a nurse or a social worker or a psychologist or someone else who has some level of expertise in the underlying source of the incapacity. So for example, it's unlikely you would find a podiatrist on an examining committee because the underlying source for incapacity is generally a neurological dysfunction or a brain injury or dementia, something along these lines. A podiatrist is unlikely to have that level of expertise. So once the examining committee is appointed, the court also appoints an attorney to represent the alleged incapacitated person. Why? Because we're considering removing some of this person's rights. We're considering removing some of my rights. I need to be represented by an attorney who's going to make sure that my rights, my due process rights, are honored, that nobody tries to ram this through the courts and stump on my rights, legal rights. And someone needs before the court to voice my opinion. I have a large part of my practice is involved with guardianship and either representing someone who's asking to find someone incapacitated, representing incapacitated persons, representing the guardians who take care of the incapacitated persons. So I have often been in cases representing an incapacitated person where I've said, no, Your Honor, my client isn't incapacitated. We have other alternatives. Or, no, Your Honor, my client objects to the proposed guardian for the following reasons. And that was the job I had, to make that person's voice heard and to make sure that their rights were honored throughout the entire process. Once the examining committee has met with the alleged incapacitated person and the alleged incapacitated person is informed by their attorney that this guardianship is pending, we then move to a hearing. And this hearing, everyone is allowed to present evidence and present witnesses, and the judge will determine first if the person legally lacks capacity, and so the alleged incapacitated person is then deemed incapacitated, if that's the judge's opinion or finding. And then we move on to the appointment of the guardian. As I mentioned before, the guardian can be anyone from the person's family. There is a preference within the statute that we appoint family members if they qualify and if they're available. And if they're not, then we will look to either someone in the person's life who's willing to serve or go to a professional guardian. So let's talk about some of the rights that can be removed and some that cannot be delegated. The right to vote can be removed, but you cannot give that to another person. The right to marry can be removed. It cannot be given to another person. The right to have a driver's license can be removed, but it cannot be given to anybody else. The right to travel or the right to look for employment can be removed, but it cannot be delegated to anybody else. There are always going to be rights that the person retains. They have the absolute right to have capacity restored if at some future date it's found that they can have capacity restored. I have been involved in many cases where someone it was presented to the court that this person lacked the ability to care for themselves, and then either through therapy, perhaps through participating in a substance abuse program, some sort of health issue was resolved, all or some of their rights could be restored. And that's really rewarding. The ward has the right to have an annual review of what the guardian has done. They have a right to see if some of their rights can be restored at any point. They have a right to have a qualified guardian. They have the right to remain as independent as possible, to be properly educated, to receive prudent financial management. They have the right to receive services from the government or rehab services. They have the right to be free from discrimination. They always have the right to access to the court. We have one case where this person requests every week to have their rights restored, and we have to honor that request. They have the right to a lawyer. They have the right to receive visitors and communications. They have the right to receive notice of all proceedings, and they have privacy rights. And the court takes those rights very seriously. The rights that can be delegated to a guardian are the right to contract. So that could include the right to sign a contract to enter into a nursing home or to employ a care agency. They have the right to sue and defend lawsuits. So the guardian may be able to either initiate or continue in the steps of the ward if there are any pending lawsuits. The guardian can apply for public benefits for the ward. Very often in my office we see this, the guardian will have to apply for Medicaid or in some cases Social Security. The guardian can take over the management of the ward's property. They can take over the decision whether or not gifts should be made of the ward's property. The guardian can determine where the ward may live or should live. Sometimes this means the ward remains in their home. Sometimes it means they have to be placed in a facility. The guardian can be given the right to consent to medical and mental health treatment on behalf of the ward, and they can have the right to make decisions about social environment. Some of the saddest circumstances are when we have the guardian is forced to make the decision about whether certain people should be allowed to visit with the ward. It may be that certain people in the ward's past have attempted to exploit or abuse the ward, and the guardian can be placed in a circumstance where they have to decide whether that person, even if it's a child or a spouse, should be allowed to continue to visit with the ward. Guardians, however, don't have carte blanche. There are certain things that they have to submit to the court for approval. If they need to commit the ward to a mental health facility, that authorization has to be provided can only be provided by the court. If there's any experimental treatment, mental health or physical treatments being considered, those must be presented to the court, and the court decides if they're appropriate. For divorce proceedings to move forward, the court has to approve. So now every year, guardians have to have a plan of what it is that they intend to provide for the ward in the way of services, either health care, social supports, residential services, and that plan has to be submitted to the court in a in a forecast form. So this is what I'm going to do for Lynn for the year 2021, and my guardian would submit to that to the court. And the court looks at that based upon what the court knows from the past and the filings and says, okay, that's a good plan. Or I don't understand, why are you moving Lynn from an assisted living facility to a nursing home? Or why are you wanting to move her out of state? And the court will either approve it or disapprove it or call the guardian in and ask more questions. The other thing, and the courts take this very, very seriously, is the accounting. Every year, a guardian has to say to the court, let me just back up. When you become guardian for someone, you do not have immediate or carte blanche access to their finances, even if you're the spouse. The funds will be segregated and put into a restricted account, and you can only remove funds from that account for the benefit of the ward upon court order. The court takes very seriously protecting the money of the ward. And so every year, if you're the guardian, you have to submit to the court all of the bank statements, copies of all receipts for any money you spent, and any checks that you wrote. And the court reconciles this based upon where you started and where you ended up. And that is a very rigorous process. So whether you're a family guardian or professional guardian, that is something that needs to get done. So, and I apologize if I speak fast. I come from a part of the country where we tend to speak quickly, and I apologize. So if there's something you didn't understand, please put it in the chat or the Q&A, and I'll do my best to slow it down and explain it better. So hopefully, at least what I've succeeded in conveying to you is that guardianship is an unpleasant experience. You are asking the court to remove rights from someone. It is a court proceeding. Much of it is private, but there is some risk that some of it could get out. And it's expensive. I'm speaking to you today from Gainesville. If we have an uncontested guardianship, that's a guardianship where everybody's in agreement, nobody's challenging it, a reasonable ballpark figure would be between $10,000 and $15,000. Now that money cannot come from the ward's funds initially. Whoever asks for the guardianship may ask to be reimbursed, and we often do that. But that money has to come from somewhere, and it cannot come from the funds of the alleged incapacitated person. Now, let me reassure you that that money does not all come to me if I represent someone who's asking to initiate a guardianship. Where does it go? It goes to court filing fees. I told you there are 2 court cases opened. There are court fees for that. It goes to pay the fees for the examining committee members. They don't work for free, nor should they be expected to. It comes to pay for the attorney who's going to represent the person who's alleged to be incapacitated. Part of it comes to my office if I'm going to be representing the petitioner. It goes to certain administrative expenses such as certified mails and things like that. These things add up. So $10,000 to $15,000 in Alachua County is about the range you're looking at. If you're listening to this and you live further down south, it may cost more. If you live in other parts of the state, it may cost a little bit less. And that's an order of magnitude. And if your loved one is at all aware that this is something that's going on, they may be distraught at the fact that someone is alleging that they're incapacitated and someone's seeking to have rights removed. Guardianship does have, as I mentioned, obligations of filing to the court, and this is everything. The court oversees the entire process, and it's not that the court doesn't care that you're a loving child or a devoted spouse. That's important, and the court respects that. But the court is not going to give family members or spouses free passes on filing the reports. And they are as onerous or as demanding on the family members as they are on the professional guardians. A word about professional guardians, if it gets to that point, they have received a lot of press in the last couple of years, not all of it particularly favorable. Professional guardians are people who have gone through a minimum of 40 hours of training on laws and certain aspects of public programs and health issues related to persons who might be incapacitated. Frequently, these are people who are retired nurses or social workers or teachers or even emergency services people who are committed to helping people whose needs may be 24/7. I like to put it this way. Guardians don't change the person's diapers, not to be crass. They make sure there's somebody there to change the diapers. So they would make sure that there are staff there or people to take care of the person who's incapacitated. They would make sure that the bills get paid. They would make sure that the person is receiving visitors, that they're getting food. So that is their job. And if someone falls out of bed at 3 o'clock on Christmas morning, they're going to be the ones who will be going to the emergency room to make sure that the ward is safe and well. A ballpark figure on their hourly rate, because they get paid hourly, depends upon their experience and depends upon where you are in the state. I've heard them go from a minimum of $55 to as high as $125 an hour. Again, depending upon level of expertise, years of experience, the demands of the particular case. Sometimes it's based upon the circuit judge and maybe where they are in the state because of the cost of living differences. You pay the guardians get paid only upon the court approving of their fees. And so the guardians don't generally get paid a retainer. But I just think it's important that you understand, you know, I think finances are an important part of this. Guardianships are expensive. I think I've made that clear. Now, I said before that guardianship is regarded by the state as the last resort. And indeed, when we file our petitions, we have to say, look, Your Honor, we looked for every other less restrictive alternative. So let's talk about what some of those less restrictive alternatives are. And I think what's also important for caregivers to know, family members, and I was a caregiver for someone with dementia, is that what I'm going to say about these least restrictive alternatives apply to all of us. We should all be having these less restrictive alternatives taken care of and provided for ourselves so that we can avoid guardianship. And if you're a caregiver, you know that the burden on you is huge and you could experience challenges and difficulties. And you need to have trusted decision makers to take care of you if this eventuality presents and you aren't the subject then of a guardianship. So these less alternative restrictives are more frequently or globally referred to as advanced directives. So what do advanced directives do? They are documents that, what are they? They are documents whereby we individually delegate authority to a third party, to another party, to make decisions for us. These could be decisions about our person, our health, or they could be decisions about our property. The beauty of advanced directives is you remain in control. Guardianship removed rights, advanced directives, you're still in control. Nobody gets control over you. Or as my kids used to say, get power over you. You are in control. You can revoke that authority, you can amend that authority, and nobody can make a decision about you that is contrary to one that you've made for yourself. So you don't lose any rights, you have autonomy, and they are far less expensive to have done. I should also say that just because someone has a diagnosis of dementia does not mean that they are incapable of doing some or all of these documents. As lawyers, we are obligated to determine if the person who's sitting in front of us has the capacity to understand the significance of the document they're about to sign. The levels of capacity that I have to look for as an attorney vary depending upon the document. So there have been cases or instances where I have felt comfortable preparing certain documents for persons who have a diagnosis of Alzheimer's, but they were capable of knowing who they would want to make healthcare decisions for them. And they understood what that delegation of authority meant. And I was comfortable preparing a healthcare surrogate for them. Now, if someone is in advanced stages of dementia or some other illness, and I don't feel they're able to understand the threshold requirements to be able to execute that document, I ethically can't do it. But absolutely, if I think that they can understand, I'm going to try and work as hard as I can to have those documents executed by the person out of respect for their autonomy, and not to have rights removed. And that's my obligation. So exactly what are these advanced directives? So advanced directives is kind of the umbrella, what comes under the umbrella. So healthcare surrogate designation, that's a big one. So in your healthcare surrogate designation, and this again, I'm going to say again, applies to you caregivers also, you should have all of these. The individual is naming a person who can provide informed medical consent in the event that they can't speak for themselves or they are not available. So this would be someone who can speak to the doctor, can speak to the pharmacist, can ask for information in the file. So this is someone that you want to, that would understand your feelings about your healthcare treatment and the different processes that or procedures that you would agree to or not agree to. A healthcare surrogate designation is not an end-of-life document at all. I will tell you that I have used this frequently for the loved ones in my life here and those that have passed on, and I used it multiple times. I used it when they were unable to understand how to make a medical appointment. Because if you're a parent and your child turns 18 today, you can't make a medical appointment for that child unless they agree to it. If you have a healthcare surrogate designation that child has given you, you can talk to the doctors. I have used it to speak to the physician, if, for example, when a parent with a memory issue or dementia would go to the doctors, if I couldn't go with them and they didn't completely understand what was going on, I could call the doctor and say, "Doctor, what exactly transpired at that meeting? What do I need to know? Oh, by the way, did mom mention this to you?" That can be invaluable. And I haven't taken away mom's rights. Mom has just given me the permission to be able to speak to her healthcare providers. If mom at some point said, "No, I don't want my daughter to be able to speak with you," then that would be it. Mom's decision would control. Now, that could be, we won't get into the weeds on that. A HIPAA authorization is another important document to have. So this would authorize, if my parents gave it to me or my child gives it to me, gives me the permission to exchange medical records between appropriate persons or to access them. Now, I'm going to stop here and just say, people are going to say, "I have that with my doctor," and you probably do. My next question is exactly how many doctors do you have? And when something happens on Friday night at about 7 on a long holiday weekend, can you get a hold of your doctor's office? So we strongly encourage people to have these standalone documents properly prepared by an attorney, and then you can send them to your healthcare providers. There are services which will save these documents and make them available to you through the cloud, because you're not going to be traveling around with these in your pocket, and they're available when you need them. I'm going to take another minute to make another aside. Why did I say with an attorney? Everybody will say, "Well, I can get it at office whatever, and get a document that's already prepared. I can go to LegalZoom. I can do whatever. I have a friend who has a friend who can copy the one that the doctor has." Here are the questions. Do you know what that document says? Are you sure, if you're in Florida, are you sure that's a Florida valid document? Do you understand the limitations on who can witness that document and who can notarize that document? Do you know if the person is going to sign that document? Are you trained to be able to know if they are competent to be able to sign it? So those are the services that the lawyer is providing you. And a lawyer will also say to you, you know, that's great that you have named someone to be your healthcare surrogate. Have you thought about what happens if that person isn't available? The lawyer is going to help you probe and determine if the people that you've appointed are appropriate based upon their skills and their availability. The next big document that people talk about as a way to avoid guardianship is the power of attorney. In Florida, these become effective as soon as you sign them. They are enormously powerful documents. And the biggest advice, or the strongest advice I keep giving to my clients when they come in, is make sure that you have people you trust as your agents under the power of attorney. They probably shouldn't be someone you have known briefly. They absolutely shouldn't be someone who's not competent to manage their own money. They aren't someone who is too busy to be able to take care of paying your bills. So you don't need to be incapacitated for this document, either one of these documents, to become effective. They're going to go live right away. And the power of attorney is really helpful, because if you become incapacitated later on and we need to do planning to get you into a facility or to get you public benefits, without that document, we may be forced to go to the court for some form of guardianship, so someone has the authority to get your Medicaid application done or get you placed into a nursing home. The other important documents that we should all have: living wills. These are documents that come into effect if your attending physician and one other determines you are either in a persistent vegetative state, a terminal condition, or the you have a terminal condition or to the end stage of a disease. This is you saying to your loved ones and to your medical care providers, I do or do not want extraordinary measures taken. I do or do not want artificial food and nutrition. I do or do not want mechanical breathing. Why is this important? At this point in your life, you may only want palliative care, and you need to have a document that makes it clear to everybody that's your wish. Someone else is not trying to second guess, or there isn't discord within the family or amongst your friends and loved ones saying, Mom would have wanted this, no, she wouldn't have. And it can be very difficult for the family. It can be very difficult for the medical providers. And you expressing your wishes here is something that everybody has to listen to. It's extremely important. You get to that point and you change your mind, that's fine. You can articulate it, you just say the word. And whatever it is that you've expressed, and if it's contrary, your word controls. Living wills do not resuscitate orders. If you sign one of these and walk out of my office and have a heart attack or a stroke, those wishes are not going to control in that circumstance unless you're in an end-stage persistent vegetative state or in a terminal condition. So that's why living wills are really important. A higher order level of sophistication can be trust. Revocable living trust or even irrevocable trust can be very wise things to consider as a way to appoint people to manage your property, either in the event of incapacity, or even if you just feel that you want someone to help you out. And they can also be a way to ensure that your legacy planning is honored. So in summary, the less restrictive alternatives to guardianship are healthcare surrogate, living will, power of attorney, a trust. These are all really important things for all of us to consider having done, the key of which are the healthcare surrogate and the power of attorney. Because I really don't like having to do guardianships. I get them, I do them because they are necessary, but we always want to try and keep someone as autonomous and respect their independence as possible. And these documents, these less restrictive alternatives, allow that to happen. And you as caregivers, I will say this speaking from having walked the walk, the amount of stress and pressure on you is going to be, or is, enormous. Life happens to you also. You should be considering who it is in the event that you are unable to perform certain things or make decisions for yourself, or you need help, who it is that you can trust to perform those activities for you and be your go-to person. The other thing I'll suggest is that you consider always having backup people, because the first person you chose may not be available because of something else that's happened in their life. They could become ill or pass on. You don't want to have to immediately worry about going out to redo these documents. The other thing I'll say is people will very often come to me and say, well, my oldest child is this, and my second oldest child is this, and so I guess that's how I ought to appoint my decision makers. Absolutely not. That is not the way to do it. You want to appoint for your power of attorney someone whom you trust implicitly and completely, someone who is competent with numbers and finances, someone who's going to be available to do that. If your child is Jeff Bezos, I'm sure he'd do the best he could, but he's probably not as available to make sure that your GRU bill is getting paid as perhaps that other child or grandchild. As far as healthcare surrogates, preferably you want someone who understands your wishes about how you want your healthcare to move forward, and someone who is not going to just say yes to whatever the medical providers are saying. I have doctors in my family. I love and respect them enormously, but just because a medical professional suggests a method of treatment doesn't mean it can't be questioned or challenged. So you want someone who's not going to be afraid to respectfully ask those questions and go down those rabbit holes to make sure that they are comfortable that whatever the proposed treatment is, it conforms with what your wishes and the decision that you would make for yourself. These people, as particularly in the healthcare surrogate, they should not be substituting their judgment for yours. They should be following through on what it is that you would have wanted to do. So with that, I would turn it over to anybody who has any questions.
All right. Thank you so much, Lynn, for sharing. That was a lot of useful information. So I encourage all of the attendees to, there we go, to enter your questions into the chat box. I have a couple questions already for you, Lynn. Mm-hmm. So you mentioned that guardianship should be used as a last resort.
Yes.
So how does the family know, how does the caregiver know when the best time is to start the guardianship process?
So the first question is, does the person who you believe lacks capacity, have they already done a power of attorney or a healthcare surrogate or a trust? And if they have, why is that not working? Now, it may be that the people that they appointed don't want to serve. They can't serve themselves. Sometimes, unfortunately, we find is the people that have been appointed are exploiting or abusing the person. So if that is the case, and if the person who is alleged to be incapacitated is no longer competent or capable of making a new appointment, that's when the guardianship should happen, or we should start talking about the guardianship. And if someone comes in here, for example, and someone says, I think I need a guardianship on my spouse or my child or my parent, the first thing we're going to say is, do they have healthcare surrogate or power of attorney, and if not, can I meet with them to see if maybe they'd be capable of doing it? And indeed, their attorney is also going to be trying to look for those things as well, if they get to a guardianship stage.
Okay, and how long does the process take for guardianship?
That's a good question. It can take, there are certain statutory timeframes that have to be honored. Statutorily, it should take no more than about 60 days. But unfortunately, because of the way the courts, even pre-COVID, are so busy, it's not always possible to get it done in 60 days. There is a process called an emergency temporary guardianship, whereby if someone is in imminent danger because they can't care for themselves and there's no one there, they're imminent danger of harming themselves, or they're in imminent danger because there's a bad actor and they are depleting their assets. There are ways for us to do what's called an emergency temporary guardianship, which allows us to get before the court, and we jump ahead of some of the processes. The person will have an attorney, and we agree, the court agrees, yeah, this is emergent. We're going to appoint somebody on a temporary basis, remove some rights, and allow this emergency temporary guardianship to control the person and or the property until we can get the permanent guardianship in place, and we've gone through all the processes. And that sometimes can still take 2 to 3 weeks. If there is a concern that someone is actually being financially exploited, before anything, we can file an emergency temporary injunction, and by statute, that has to be done within 72 hours. But that's where we really, and that only has to do with finances.
Okay. And then do you have any advice for caregivers on where they can go to find an elder law attorney or how to find one?
Okay. All attorneys in Florida, if they're licensed and they're in good standing with the bar, they can do any of this work. I am a board certified elder law attorney, and my practice is focused on elder law and estate planning. Why am I telling you all about me? I don't do divorces. I do not do bankruptcies. I don't even do property. So if I would not attempt to do documents for people with those questions, I am legally allowed to do that. So my suggestion would be that you find an attorney who understands elder law related matters. There are many people who will say they do elder law, but they may just be doing it along with everything else that they do. You can find a listing of board certified elder law attorneys by going to the Florida Bar website. And anybody who's been certified, which means that we've passed an extra level of scrutiny and taken another exam to demonstrate expertise, you can go to the Academy of Florida Elder Law Attorneys, abbreviated AFELA, AFELA, and that will give a listing of all elder law attorneys in the state of Florida that are part of the Academy. I always feel the best way for clients to come to me is if they come as a referral from someone. You may find that some physicians are familiar with certain attorneys that they've worked with because the physician may be the first person who's seen some of these issues present. If you have, if you're a member of if you go to the senior center here in Gainesville, you may want to talk to some of your colleagues down there about who it is that they may be working with. An elder law attorney is someone who's going to be able to help you deal with the crisis, but also help the family throughout the entire process. So that's, I cannot stress strongly enough, please, 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 do not think that you are saving money by doing either a download of a document, borrowing something from somebody else, or going to the stationery store and trying to copy something. Not to be disrespectful, I will make far more money because those things have to be corrected than I could ever ethically charge you for doing the documents correctly in the first place. And most of us feel the same way about LegalZoom as well.
And you mentioned that for guardianship in Gainesville, it's between $10,000 and $15,000. Are there programs or anything that could help with the cost of that, or?
No, the only cost that could, well, if the person who is alleged to be incapacitated is indigent, so they really don't have any more income other than supplemental security income of about $771 a month. If they qualify as indigent, the court or the state will pay the filing fees, will pay the fees of the examining committee, and will pay the fees of the attorney who's appointed to represent the alleged incapacitated person. There is no program to pay the fees of the attorney for the petitioner. And often that's the person who's doing the heavy lifting work. So there's no way, there's no source for that. But if you can get those other three waived, because the alleged incapacity is indigent, you're probably saving about 50%.
Okay. All right. Well, thank you, Lynn, for taking time out of your day to speak to us. Thank you all for participating in our presentation today. If you have questions, continue putting them in the chat box. And thank you all so much.
Thank you very much.